Good morning, gentlemen. Ladies and gentlemen, I'd like to welcome you to County Court at Law number 2. This morning we have our arraignment docket. And what the arraignment docket is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. We handle misdemeanor cases in this court. Therefore, the case that you have is a misdemeanor case. The difference between your felony cases and your misdemeanor cases are felony cases are normally referred to as your most serious type cases, and your misdemeanor cases are normally referred to as a petty offense. It does not mean that it's serious. It just means that it is not as serious. And when I say serious, what I'm talking about is the range of punishment. That is what the punishment can be for the offense. For a felony case, felonies are divided into 5 categories. You have a capital murder, first-degree felony, second-degree felony, third-degree felony, or a state jail felony. If you have a capital murder case and you get convicted, the range of punishment is life or death. For a conviction for a first-degree felony, the range of punishment is 5 to 99 years to life, fine up to $10,000. For a second-degree felony, the range of punishment is 2 to 20 years, fine up to $10,000. And for a third-degree felony, the range of punishment is 2 to 10 years, fine up to $10,000. Now, all of those first 4 felonies, a person can be sentenced to the state penitentiary. Now, for the last category of felony, which is a state jail felony, the range of punishment is from 6 months to 2 years in the state jail, a fine up to $10,000. Now, for your misdemeanor offenses, misdemeanors are divided into 3 categories. You have a class A, a class B, and a class C. If you have a class C misdemeanor, that means that your case was appealed from a JP court or a city court. You cannot be given for your misdemeanor cases, you cannot be sentenced to the state penitentiary. However, if you have a class A or class B misdemeanor offense, you could be sentenced to the county jail. For a class C misdemeanor offense, you cannot be sentenced to jail. You can only be given a fine only. Now, if you have a class C misdemeanor, as I said earlier, you can only be given a fine. If you have a class B misdemeanor, the range of punishment is anywhere from 0 days to 6 months in the county jail, a fine up to $2,000. If you have a class A misdemeanor, the range of punishment is anywhere from 0 days to a year, which is 365 days in the county jail, and or a fine from $0 up to $4,000. Or you could be given, your punishment can be anywhere in between the fine. That is, if you could be given a fine from $0 or anywhere in between to $4,000 for a class A. Your punishment can be jail time anywhere from 0 days to 365 days or anywhere in between. And that's the same thing. So when I say your range of punishment starts at the minimum to a maximum, you could also be sentenced anywhere in between the minimum and the maximum. Now, the form that you have filled out, that form basically, the first form is the judge's explanation of rights of defendants without an attorney. In that form, it states that as a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number 3, you may represent yourself. If you do not have enough money to hire an attorney, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. If you have enough money to hire an attorney, then your case will be reset to give you time to do so. Now, you may not speak to the prosecutor about your case unless you sign a written waiver of right to be represented by an attorney. That is, you can waive your right to have an attorney if you desire to represent yourself, but you cannot speak to the prosecutor until you sign a written waiver. And a written waiver is the second page on the tablet that you have before you. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, it states, defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my attorney, you put your initials on the first line to the left. If you have already hired an attorney, then you put your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for court-appointed attorney, then you put your initials on the third line to the left. If you have already been appointed an attorney to represent you, then you put your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney and represent yourself, then you'll put your initials on the fourth line to the left. Now, for those of you who are waiving your right to an attorney and you desire to represent yourself, you'd have to fill out the second page, and the second page reads as follows. Waiver of counsel for purposes of entering a guilty plea or proceeding to trial. It says that I have been advised of nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised the first day of February 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right. And if that's your choice, then you'll sign the document where it says defendant and put it on today's date, which is February 1st of 2022. Now, as a defendant, you also have other rights. You have a right to have a jury trial. That area over there where you see those 12 chairs, 6 citizens will be selected to sit on your case, and they will decide whether or not you're guilty or innocent after listening to all the evidence in the case. You also have a right to waive or give up your right to have a trial by jury. And by doing so, that simply means that you will not be having a trial by jury. And your case will come before the judge. Your case can come before the judge in one of two ways. It could come before the judge by way of a trial or by way of a plea. If it comes before the judge by way of a trial, we call that a bench trial. And that just simply means that the judge will be the judge and the jury in your case. If you desire to plea to your case, that is, if you'll have an opportunity to talk to the prosecutor, you or your attorney will have an opportunity to talk to the prosecutor, and they will see whether or not they can work out a settlement on your case. We call that settlement a plea bargain agreement. If you are able to work out a settlement, the court does not have to follow that settlement. However, if the court does not follow the settlement or the plea bargain agreement, you'll be entitled to withdraw or take back your plea. Now, if you and the state are unable to reach a plea bargain agreement and you still want the judge to determine the punishment in the case, we call that an unagreed plea. And but if the case comes before the judge by an unagreed plea, if the judge does does not follow the plea bargain agreement, then, well, if it comes before the judge, then the judge basically, it's not a plea bargain agreement. The judge will set the punishment, okay? There's no agreement between you and the state, and so the judge will set the punishment. You also have a right to have a trial, not only a trial by jury, but you also have a right to have witnesses that come to court. And what witnesses do, they can testify for you or against you. And your attorney can ask them questions. If you're represented by an attorney, or if you're representing yourself, then you'll be able to ask them questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses that come to court. That is, you have a right not to call any witnesses in your case. Now, if you do not call any witnesses in your case, it does not mean that the state will not call witnesses in your case, because they are the ones who have the burden of proof, and so they will call witnesses in your case. You also have a right against self-incrimination. Self-incrimination is commonly referred to as taking the fifth. You may have heard people saying, I take the fifth. In essence, I don't want to testify. What that basically means is that you have a Fifth Amendment right against self-incrimination. You have a right not to testify in your case, and no one can force you to, the state cannot force you to testify. You can waive or give up that right. And by waiving or giving up that right, you will be testifying in your case. Everyone in here who is here for arraignment, you have been arrested. And so that just simply means that every day that you spent in jail on your case, you can get credit towards your punishment. If the state offers you, if you've been in jail 5 days and the state offers you 5 days in jail, that simply means that you will not have to do any more time in jail, because you'll be given credit for the time that you have already served. Now, for every day that you spent in jail, you get credit at $100 per day that goes towards your fine and your court costs. So if the state is offering a fine and court costs of $500, and you spent 5 days in jail, which is $500, then you would not have to pay anything, because the time that you spent in jail has already paid it off, and therefore the court costs will be taxed and retired. Now, if you're unable to pay the fine, then your fine can be converted to, well, we could put you on a payment plan to pay it off over time. But if you cannot pay it off at all, even if we put you on a payment plan, then we can convert the fine and court costs to community service. And you get credit at $12.50 for each hour of community service that you do. And so if you do 8 hours of community service in one day, that's $100. Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program for first-time offenders. And when I say Jefferson County, I'm talking about the DA's office. The DA's office will dismiss your case. And if you successfully complete the pretrial diversion program, you can get the case expunged from your record. Expunged means erased, deleted, or wiped off from your criminal history. Now, also, if you are a veteran of any one of the branches of the United States military, the DA's office has a program that is called Veterans Court. It's for veterans only. It is also part of the pretrial diversion program. You get into the program, you complete the program, the case is dismissed, and you can get it expunged, which means erased, deleted, or wiped off from your criminal record. This court has a program that is called that is called the CSI program. CSI stands for Community Safety Initiative. It is a program designed to address the issue of recidivism. Recidivism means when a person commits crimes over and over. And so I started this program in March of 2017, within 100 days of taking the bench. And the program is designed not only to address recidivism, but the program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and go to church. The way the program works is we have partnerships with agencies in our community. We have a partnership with Spindletop Center. Spindletop Center is our local mental health center. And we have counselors and mental health deputies who can assist you with your case. And basically, when I say assist, the mental health counselor will do a private interview. Spindletop can develop a treatment plan after doing an assessment, and the treatment plan could either be inpatient treatment or outpatient treatment. And it's for individuals. You don't have to be insane or incompetent, but the program is designed for individuals who have mental health issues. It could be bipolar, schizophrenic, person could be suffer from depression, anxiety, post-traumatic stress, a whole host of other mental health issues that Spindletop will be able to address. The other thing is, if you have a problem with drugs or alcohol, Spindletop has a program called ATAR. ATAR stands for Addiction Treatment and Recovery, and it's for individuals who are 21 years old or younger. You can participate in that program. And now if you're 21 years, if you're over 21, then we have OZAR, our local drug and alcohol council, who can also provide services. And the services will entail a screening, an interview, a treatment plan, either outpatient or inpatient treatment for individuals who have issues with drugs or alcohol. Now, if you are unemployed or if you are looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University, and Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program. You will be trained in one of the three areas that you select. It could be the hotel industry, the shipping industry, or the chemical industry. Once you are trained in one of those areas, then they will assist you at getting a job in the area that you are trained in. If you have not graduated from high school and you do not have a high school diploma, then CICE has a program where you can get your GED. Now, all of these programs that I have just mentioned are free. Does not cost you anything. Only thing you have to do is have a desire to be in the program and take the time out to participate in the program. All of these programs, as I stated earlier, was started in 2017, March of 2017. I tell people this all the time: when you come to county court at law number 2, we do not have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this bench, and we're trying to make a difference in the community in which we live. And I say that we're trying to make a difference. It's not because we are a difference, but we're trying to make a difference in the lives of those individuals that come before the court, and we're trying to make a difference in the community. We are trying to produce productive people because we believe that by producing productive people for the most part do not commit crimes. And if they don't commit crimes, then it makes Jefferson County a safer place for all of us. And so if you, I tell people this all the time, in county court at law number 2, we do not just give time, we take out time. And that simply means that we don't just arrest the problem, we address the problem. And so If you're interested in any one of those programs, we have information that we can give to you so that you can participate in the program. We also have Deputy Hinton, who is our mental health deputy. He's here from Spindletop. He's going to come forward and tell you a little bit about the program that Spindletop has to offer. Deputy Hinton.
Thank you, Your Honor.
You're welcome.
My name is Steve Hinton. I'm a mental health deputy licensed by the state of Texas. And the reason I am here is because the judge has graciously allowed me in his courtroom because he cares for every single person who comes before his court. But the judge has found, more so than not, that people who come to his court have legal issues commonly have mental health or substance use disorders. And the judge believes if we can address those underlying issues, we can get you out of the cycle of arrest. What that means is, if you've been here, this is your first time, or this is your 10th time, there's opportunities for you, there's services, there's options that you can explore to get you out of the cycle of arrest. At the very least, I'm going to give you this flyer. It tells you a little bit about what we do. It also has a 1-800 crisis line on there. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. We'll have a number there for Spindletop that you can get into services if this applies to you, that you can get into treatment plans that would best suit your situation and give you the quality of life that maybe you're looking for. Maybe this doesn't apply to you, maybe it applies to a family member. If so, I still want to get this in your hands so you can take this back to your family and give this to them, and we can advocate on your behalf for them or for y'all. We can help you with appointments if you need that. Whatever it takes to help you, that is our goal, and that is the goal of the judge for allowing us in his courtroom for this very purpose, is to help y'all. Does anyone have any questions? As the court proceeds, I will be visiting with each of you individually. Your information is private. We will not talk about it outside of your permission. Everything is voluntary. You do not have to do this, but it's up to you if you want to explore this and see if there's some options or services or opportunities out there that would best suit your particular situation. Thank you. You're very kind for listening. Thank you, Your Honor.
Okay, thank you, Deputy Hinton. Now, ladies and gentlemen, our court staff has passed out some paperwork to you. The court is going to go over that paperwork. It's going to take a few minutes. So at this time, we'll be in recess.